So when you have a product case and someone's been injured, right, and you have the product, you want to look for one of two options. Was it designed improperly or was it manufactured improperly? So if it was designed improperly, that means that every single product that came out was also going to fail. If it was manufactured improperly, that means that the design was okay, but something happened in the manufacturing process that made this product more likely to fail than the other products. So if you're injured by a product, I can almost guarantee you that the company that manufactured and designed that product will at some point tell you, you misused that product, right? That's the number one defense. It's that you didn't know how to use this product and that's why you're injured. But the reality is that's not true. That's what they want you to think. The reality is that there was either a design issue or a manufacturing problem. So do not initially buy into the idea that you did anything wrong, because the reality is you haven't. But what will they say? They'll say it was misused. It was used improperly. And I have cases that involve batteries. Well, how do you use a battery improperly if you just put it in the device? So companies would love to tell you that it's your responsibility, it's your fault. But I'm here to tell you it's not. It's not. And the product likely should never have injured you. We just have to prove what was wrong with the product. So if you have a strong case, sure, they're going to say what they want, but understand we can cut through that and a jury will understand that they injured you when it wasn't your fault. If you've been injured by a product, the last thing you should be doing is reaching out to the manufacturer. They're not your friend. They're no different than a defense insurance company, right? They'll offer you a new product. May offer you a couple $1,000s and act like they're doing you a favor. But they are not. They are not on your team. The reality is you have a claim, and that's why they are trying to get ahead of us. If you've been injured by a product, I recommend you contact product plaintiff's attorneys like me, right? We know how to hold them responsible. They're trying to avoid us and cut us out of the equation. So to the extent that you get contacted by a manufacturer or you're injured by a product and you wish to contact the manufacturer, I'd recommend you contacting a plaintiff's personal injury attorney. There's likely multiple different parties that are responsible. It would start with your retailer. Who did you purchase the product from? And then it goes up. But think of it this way. Who profited from the product? Your distributor, the designer, your manufacturer, your retailer. Each one of them can be held responsible in a product claim. So in every case, there's going to be a statute of limitations, right? Depending upon the state that you live in. I've litigated product cases in 26 different states throughout the country. And what I would tell you is that the number one thing to do, though, if you are injured by a product immediately, is to contact an attorney. Why? Because you want to make sure that your rights are being protected. You want to make sure that the investigation into the product is being conducted immediately. In product cases, without the product, it's hard to prove that there's a design defect or a manufacturing defect. So if in product cases, if we don't collect the evidence and documentation immediately, you could have no claim. So delays in product claims are not good for your case. And I would recommend that if you are injured, call 911 right away, but then follow up with a personal injury attorney.